Good afternoon. I'm John Ravitz, the Executive Vice President and Chief Operating Officer for the Business Council of Westchester. And we want to welcome everyone to the fourth of what has been a really exciting and informative series, building in the post-COVID world, tips and best practices for developers, builders, and contractors. This series was created by two BCW members who we're so fortunate to work with, Levitt First Insurance and the Building and Realty Institute, BRI. Both organizations are leaders in Westchester County and again have brought this series together that has not only continued to be heard on our website in our Business Resource Center, but also this is going to be recorded live on Facebook Live. So more and more people will get a chance to hear the content of this material. Just one upcoming event for the Business Council of Westchester. I hope you'll all be able to join us at our Key Bank Leadership Series next Friday, October 29th at 9 a.m., our virtual event. Our guest will be the United States Senate Majority Leader, Charles Schumer. So again, please register for that event. You can share it with your colleagues and friends as well. It is my pleasure to introduce Tim Foley, who is the Chief Executive Officer of the Builders and Realty Institute. Again, Tim has been a leader, bringing his members all the most updated information during this last year and a half during the pandemic. And Tim, thank you again and also for Ken for putting this series together. I'm turning it over to you.
Thank you so much, John. And we want to thank the Business Council of Westchester for supporting us on this webinar series. And we want to thank our co-sponsors, Levitt First Insurance. This is the last in what has been a four-part series for developers, builders, and contractors, focusing not only on the new challenges and the new problems, but on the best practices for conducting your business in what we hope will soon be the post-COVID world. On our past few weeks, we have focused on OSHA inspection and site safety, on cyber attacks that are increasingly targeting construction and contractor businesses like yours, and on how to navigate the permitting and application processes for municipalities. And all of those previous webinars continue to be available on the Business Resource Center on the Business Council of Westchester website. Today, we're focusing on the issues of legal landmines, both a reminder of what businesses like yours always need to take into account, and some of the changing circumstances based on the COVID-19 pandemic. We have three superb speakers who will be presenting. If you'd like to ask questions of any or all of them, please use the Q&A feature on your Zoom toolbar. We will have dedicated time at the end to take as many questions as we can. Our first speaker will be Thomas Tripodianos, who is the managing partner of Welby, Brady, and Greenblatt, LLP, where he is involved in all aspects of construction, labor, and real estate law, representing everyone from the project owner to the supplier and the design team. Welby, Brady, and Greenblatt has offices in White Plains, Manhattan, Albany, New Jersey, and Connecticut. Our second speaker will be Carl Finger, who is an attorney and principal of Finger & Finger, a professional corporation. He is an attorney practicing in real estate, cooperative and condominium law, landlord-tenant, commercial litigation, personal injury litigation, workers' compensation, and tax certiorari. Finger & Finger assists clients throughout New York City, Rockland, Putnam, and Westchester counties. And our final speaker will be Jason Susciano, who is co-president of Levitt First Insurance, headquartered in Tarrytown, New York. With 52 years in business and a staff of 70, Levitt First is the largest independently owned insurance and bonding broker in Westchester. Levitt First is the insurance advisor to the Builders Institute and has been recognized by Insurance Business America magazine as a top specialist broker for construction insurance. Levitt First construction team focuses on providing comprehensive insurance coverage and risk mitigation services for their contractor clients. Without further ado, take it away, Thomas.
Good afternoon, everyone. Thank you to the BRI and the BCW, as well as Levitt First, for putting this program together and giving us the opportunity to speak. And thank you to all the audience for tuning in, whether you're live or hearing this at some later date. So let me just share my screen for 1 second. Can everyone see that? Yes, no?
Not yet. Can you try again?
Very good. There it goes, right?
That's perfect.
Perfect. Okay. So I guess we'll skip these slides. Okay. So I'm going to talk about two things during my segment. They're both statutory, the first being the HERO Act and the second being the amendments to the Construction Wage Theft Act. So just when we thought we were over the pandemic and things were sort of returning back to normal and we were done with all the regulations that the state and federal and local governments were enacting, along comes the HERO Act. So what is it and where can I find it? Where it's part of the New York labor law. It's added two sections, 218B and 27D, for those of you inclined to look it up. Section 1 requires the creation and adoption of model safety plans and also has provisions with regards to discrimination and retaliation against employees who choose to avail themselves of the what the Act affords. Section 2 deals with the establishment of joint workplace safety committees, labor and employee committees. So it's not a new act. It was enacted in May of 2021, but it was recently implemented. So, and how does it get implemented? Well, there's a declaration by the governor that there is a highly contagious communicable disease that presents a serious risk of harm to the public health. Its acronym HERO Act requires the state DOL and the Department of Health to implement both standards, workplace safety standards, as well as the creation of model plans, which are industry specific, all of which will be dealing with airborne diseases. HERO Act stands for New York Health and Essential Rights Act of New York. It doesn't apply to seasonal infectious diseases such as the flu or the cold or something like that. There has to be a designation by the Commissioner of Health or the governor that there is a serious harm being posed. So Governor Kathy Hochul on Labor Day designated COVID-19 as qualifying as such a disease. So that triggered the requirements under the HERO Act. I'm going to go over 5 things to know about the HERO Act, which is very summary fashion. If you have any further questions, obviously, feel free to put them in the Q&A or contact me later on. I'll be happy to help out. So who does it apply to? So all private employers with work sites in the state of New York are required to implement a safety plan to prevent employee exposure to COVID-19. This is very similar to most of the plans and programs and protocols we've all been following at the workplace to prevent the spread of COVID-19. You can create your own plan. I don't know of anyone who has actually done that. Most people have implemented and adopted the Department of Labor model plans that are available on their websites, and in a later slide I will have the URLs for that. If you do for some reason choose to establish your own plan, you have to adhere to the minimum standards that have been promulgated by the DOL. If you haven't yet adopted a plan, you are late and in violation of the HERO Act. So what do the plans include? Like I said, most of the stuff that we're all used to: health screenings at the beginning of the workday, face coverings and personal protective equipment, which has to be provided by the employer, physical distancing requirements, hand washing and sanitizing facilities, cleaning and disinfection protocols for equipment and tools, and the use of PPE. 3, employees covered by the plan include part-time workers, independent contractors, domestic workers, home care, personal care. Basically, anybody who gets paid to do something is going to be covered by the Act. It even extends to staffing agencies and subcontractors. Interestingly, the legislature in its wisdom has deemed that the HERO Act does not apply to itself. So all governmental agencies and public authorities are excluded from the HERO Act. Or employers and their representatives are barred from retaliation or discrimination. So there are whistleblower provisions in the Act which prevent you from taking any adverse employment action to any employee complaining about violations of safety protocols with relation to the airborne infectious disease, or if the employee in good faith determines that coming to work would expose them unreasonably to contracting the disease, and therefore acted in good faith and not coming to work. If they choose to avail themselves of that, the employer is forbidden from taking any adverse action against that employee for that reason. 5, if you have not yet adopted a prevention plan, you're subject to a fine of $50 per day until you do so. Those who fail to follow the plan can get sued or fined by the government, and the fines range from $1,000 to $10,000. There is a private right of action also afforded by the HERO Act, which would double those damages. This is a slide that has the URLs for the model plans. The standards are on top. I've only given you the construction industry references. One is for infield plans and the other one is for office plans. So it is possible that you will have to adopt multiple HERO Act plans depending on what type of work site we're talking about. The deadlines, like I said, if you haven't adopted the plan yet, you are late. So the deadline was September 4th to adopt and communicate the plan. In order to communicate the plan, you would post it where you would post all your other labor law posters. That could be at a job site trailer. It could be, in the break room, in the office, wherever that case may be. You would also incorporate it into your employee handbook as an amendment if you have a handbook. You're not required to create a handbook just for the HERO Act. You also have to readily make it available for any employee, independent contractor, union, if you're a union employer, and also the labor commissioner and any health department investigator that would happen to visit your site. A bigger, I think, more immediate concern is the Construction Industry Wage Theft Act. This is the second statute I'm going to be talking about. So Labor Day week was busy for the new governor. So on September 6th, she signed the law into the act, rather, the bill into law. And what this does, it creates joint and several liability to prime contractors if there is a situation where an employee of their subcontractor of any tier has not been paid a proper wage or benefit. So again, it's not limited to wages. It includes benefits and wage supplements as defined in New York Labor Law Section 198. This would include reimbursement for expenses, your usual benefits of health and welfare and retirement, any vacation pay, separation, or holiday pay would also be included. If there is a failure to pay, all the remedies that would otherwise be available under Section 198 of the law would also be available here, and they would include the expenses of enforcement. Obviously, 100% of any unpaid wages times 2, because it's liquidated damages, and that is the measure. So it's twice the unpaid wage and benefit, prejudgment interest, and a $5,000 penalty plus attorney's fees if you fail to provide the proper wage notice at the commencement of the employment, and also a second $5,000 penalty if you fail to provide pay stubs. Also, in the case of a action being commenced, the employee would be entitled to attorney's fees and costs in that action. The act comes into being into Section 198E as well as an amendment to General Business Law, Section 7756, and it comes in as a -F provision. It will take effect on January 4th, 2022. It will apply to all renewed, modified, and amended contracts as of that date. Unlike the wage actions, which usually carry a 6-year statute of limitations, violations of this provision of the Act only carries a 3-year statute of limitations. Number 4, you cannot contract your way out of these obligations. So an employee cannot waive the protections of the Act, except if done so through a collective bargaining agreement. So therefore, the law will apply to all non-union contracts without exception. How do you protect yourself? Well, you can contract for indemnification by your subcontractor, and you can also sue your subcontractor if there is resultant liability because you had to pay an employee who wasn't paid the proper wage. You cannot, again, in that contractual clause, attempt to water down the protections of the Act in any way. Another protection that is afforded to the contractor, and this is the amendment under the General Business Law, is the ability to request copies of certified payrolls showing the status of wage payments and benefit contributions. Those of you who have been involved in any sort of public work are certainly familiar with certified payrolls. And that is the same type of payroll that you can request on private jobs from your subcontractors and any intermediaries down the line. This is going to be your main enforcement mechanism. This is the only way that you can actually know who is being paid and for what. You can ask your subcontractors to also identify any of their vendors and provide contact information for you to investigate further down the line, as your liability is not limited to those with whom you have a direct contract. If the subcontractor fails to provide this information, then you have the right to withhold payment from them until such time as they do. The legislation is designed to encourage contractors to conduct regular audits of their subcontractors' payroll and have tight and strict enforcement mechanisms and administration before releasing payment to the subcontractor. Problem is, even if you're diligent in reviewing payroll records, there is likely items that you're going to miss because they don't appear on payroll records. For example, situations where a worker is working at the site but has failed to appear on a certified payroll, either in totality or a portion of their hours. Just because they haven't checked in to a site, as long as they're working, they should be earning a wage for which you would be responsible. Things like the notice that is required at the commencement of employment, as well as your pay stubs. Again, that is not something that you would see on certified payrolls, so you would really have no idea whether the subcontractor is providing those. That is something you would want to kind of work into your subcontracts as a clause, requiring that with each requisition for payment that you receive from the subcontractor, this would be some of the supporting documentation that you would want to see from them. Also, frequency of pay requirements. Excuse me. So as you know, in New York, there has to be a minimum of a 2-week or 1-month payroll for wage earners. So if the subcontractor is failing to pay in that frequency, that is something you could possibly have liability for. Let's see where we are in time. Yeah, I think we're there, right, guys? So.
Yep, we're at time. So thank you very much, Tom. As a reminder, again, there are already questions coming in the Q&A, and some have been sent in by email, so you can continue doing so. Next up is Carl Finger.
Thank you, Tim. I want to also thank the BRI and BCW and everybody for and Levitt First for planning this event. Hopefully, everybody will watch it many, many times on replay and drive a lot of traffic to the BCW and BRI face pages and things of that nature. Let me share my screen, which is, of course, going to be slightly challenging, but let's see if I can do it. Slideshow. Slideshow. Okay, does that seem to be working? Hopefully that's a yes.
We can see it. It's not quite full screen, but we can see it.
Oh, give me 1 second to work that out. All right, let me leave it for now so I can get through it. I think it's because I have my screen vertical, so you guys will suffer through and then we'll hopefully get a better copy to anybody who needs it. So thank you to the BRI. This is a section of the presentation where I am looking at the idea that normal, as Tim put it, and getting past COVID is not quite necessarily going to be the same as before. And I think some of the laws that Tom was talking about, the HERO Act and the requirements indicate that even when we get back to normal, there are going to be different thoughts and considerations based on the pandemic that we need to be aware of. Unlike Tom's, it was a little bit different from Tom's presentation, where he was giving you a lot of what you have to do in order to comply with the law and not to, which is very important. I'm going to try and provide you some considerations on things that you may or may not want to do given the circumstances that we're now faced with and we expect to be faced with in the future. So I entitled this Contracting During and After COVID-19 Practical Considerations. And actually, what I'm thinking is COVID events require reconsideration of some standard contract clauses. Now, I say reconsideration, recognizing that many clauses that you have in your everyday contracts until now probably did not garner a lot of attention. And I think, the idea is that some of those clauses, as well as some other things, need to be thought of a little differently going forward because the circumstances are now require that. And some of the clauses which we've talked a lot about over the past year or now a year and a half or more are what's known as a force majeure clause, clauses pertaining to notices, clauses pertaining to changes in law and who's responsible, other impacts that are addressed in the contract, and other languages. So what I want to do is give you an idea sort of practically of things to think about and, to discuss with both maybe with your attorney and certainly with anybody who you're contracting with, and consider revising as you go forward. In general, most contracts that you use will have a definition section. We want to try to think about things that maybe we didn't specify before, but that require some greater specificity now. So obviously COVID-19, but beyond that, we may want to specify what other pandemic, epidemic, other similar conditions might be in a way that they now have meaning in the rest of the contract as we go through it. And the reason for that is we didn't often indicate pandemic in things like force majeure clauses and delay clauses and things of that nature. So however you address these things, you want to make sure preliminarily that they're defined in a way that everybody understands what we're talking about, so that you don't have an argument before you even get to first base. I call it laws, but we want to spend some time defining what types of laws could affect the contract: executive orders, judicial orders, Department of Health orders, building department orders. We now realize that there are all different types of not just legislation, not just statutes, and not just ordinary regulations that can impact the way contracts are met, the way contractors and owners meet their obligations in contracts and the way contracts are impacted. I put COVID-19 condition and unknown COVID-19 condition being essentially things that we know about right now and can anticipate, and the general concept, unknown things that that we want to address that may happen, but that we're not aware of right now. So we want to say, in general, that would be things that could, again, delay, et cetera, but that we can't describe with particularity right now. One of the big issues that we all are familiar with is delay, and how you address delay in your contracts and your agreements. The point here is that I think a year and a half ago, it's possible somebody could argue that when I say COVID-19, speaking of definitions, I'm talking about the impacts of COVID-19, work stoppages, supply delays, things of that nature. To the extent, especially with regards to COVID-19, that a year and a half ago, maybe they were considered unforeseeable, it's probably safe to say that at this point in time, many of those impacts, we could not get away with suggesting that they're unforeseeable, and we need to be aware of that and address that specifically in your agreements. What's foreseeable, and certain things, we know are foreseeable and you can specify them. There are other things that maybe are less quantifiable, and we generally in law try and use a reasonableness standard to define what might be an unforeseeable event. So we want to make sure that we are really thinking more about what is likely to be foreseeable and unforeseeable and cause delay, and how we are going to address that, who is responsible and what the impacts are. Another thing another item which came up, and I think we should be thinking about, is owner suspension of work. So in the past, it was quite, I would say, infrequent. Owners wanted work done, especially when you're talking about maybe renovations, residential construction, things of that nature. If anything, there was anxiety surrounding not having enough people on a job, not moving quickly enough. Now, the problem is you may have a situation where you're entitled to continue the work under the Department of Health regulations, et cetera, but if an owner may not want you to, perhaps it's a renovation within a house or within an office where they are all the time, and they want you to stop work or delay work, or maybe work actually with less people. So we want to address, if that happens now, what the result would be. And the results are obviously far-reaching and include not only delay, but potential increase in cost, as well as other scheduling issues for the contractors and for the subcontractors. So that's something to think about, that, addressing earlier, addressing in the contract will prevent a problem later on. Compliance with new laws and orders. As I was mentioning before, we now know there are so many different new laws and orders and types of laws and orders and regulations. We want to have an idea in the contract to specify if there are these types of restrictions. How does that delay get apportioned? How does that cost get apportioned? You have general situations where there may be general restrictions, and then you may have a specific incident where perhaps contractor has, you have too many people on a job and you're only allowed to have 2 people, and now to comply with the regulations as a result of that specific incident, the work has to slow down, or there's a stoppage or whatever. So you have sort of general situations, and then you have maybe specific incidences, and you want to, I think, try to address those ahead of time as much as possible, so that they're avoiding an argument later on. Obviously, something we're, I think, quite familiar with now, but you have additional costs that's caused by price escalation, supply disruption, and compliance with orders and laws and regulations I just mentioned. How that's going to be attributable, how that's going to be, who's going to be responsible for those. The idea here, again, is to use your definitions for what's sort of potentially foreseeable, what's not foreseeable, what could be known, could not be known, and try to, perhaps using a reasonable standard, apportion responsibility between not only the owner, but the contractor. And oops, went too fast. Here we go. And then, the other thing to be aware of is subcontractors in that scenario. Who's responsible? And as a contractor, you want to be aware of that possibility. And then these are just some ideas, but if the criteria that you set aren't met, based on regulations, based on certain circumstances, you want to apportion the responsibility. Could be, depending on what the item is, maybe the owner pays all of it, maybe the owner pays half of it, depending on what causes the delay and what your criteria are. Maybe the delay is excused for the contractor, or maybe delay beyond a certain amount of time is excused. So those are just a few ideas. There are all kinds of scenarios and all kinds of options there, but the idea is to put something in the contract so that you each know what you're getting to the extent possible. A word on force majeure, impossibility, and impracticability. The language you use in your contracts, and this sort of comes full circle to what I said at the beginning, is going to have a lot to do with how that clause applies to a particular incident. And these are clauses that, while we may have paid some attention to, I think we need to pay a lot more attention to now and consider being a lot more specific, with the idea that what was foreseeable 18 months ago is most likely not foreseeable today. Oh, I said that backwards. What was not foreseeable 18 months ago is most likely foreseeable today. And so I leave you with that thought. And that's what I think is mostly what you want to think about going forward in all of these contracts. And let's see if I can stop the share.
Thank you so much, Carl. And then our final speaker is Jason Susciano.
Hi, good afternoon, everybody, and thank you, Tim. Appreciate the Builders Institute and the BCW hosting this event. I'm going to share my screen. We good, Tim?
We are.
Okay. Again, my name is Jason Schijano. I'm co-president of Levitt First Insurance. And in addition to construction insurance, we also do insurance for real estate, general business, as well as personal insurance and surety bonding for construction. And we are Westchester's largest independent insurance broker. So wanted to address, the two attorneys on this presentation, Tom and Carl, addressed the laws affecting construction business. And then the question needs to be asked, well, what happens if somebody accuses you of violating the law and you get sued? Or somebody gets sick from COVID relative to the laws, the HERO Act, et cetera, and you have legal exposure. So first I want to talk a little bit about COVID, and then I'll talk about some non-COVID exposures as well, pitfalls that construction contractors often face. With respect to employees getting sick on the job from COVID, they can attempt to file a workers' compensation claim. And remember, if your employees get sick, they can't sue you as your employees. They have the right, and their right stops at filing a workers' compensation claim. So they can attempt to file a work comp claim for COVID infection. However, we have not seen a lot of these. It's very difficult to prove exactly where and how and when you picked up COVID. And unless you're working in a hospital or a nursing home where you're constantly being exposed to infection, it's hard to imagine that a workers' comp claim on a construction site for one or two individuals would be successful. But that would be up to the carrier to determine. With respect to if you're a project owner, a developer, a building owner, if you get sued, somebody claiming that you were negligent in protecting against COVID infection, that you weren't following guidelines, and as a result, someone or a group of people got sick, it's important to realize that most general liability policies, which are the policies that respond to sickness and bodily injury, have exclusions, and they are more common than ever now. If you didn't have them on your expiring policy, likely you'll have them on your renewal. Exclusions for a virus or communicable disease. So, there's some potential gray area and wiggle room on the general liability policy, but if that exclusion is on there, it's almost certain that that claim will be denied. Other types of liability policies, such as a pollution liability policy, it's possible that there may be coverage there. Pollution liability policies vary widely in terms of their language and endorsements. So you'd need to have your broker review a pollution liability policy to determine if coverage for a COVID sickness claim would be possible through that policy. Obviously, there are multiple things that you can do to mitigate risk, starting first and foremost with following the laws, regulations, and best practices that have been discussed not only on this call, but I'm sure ad nauseum with your advisors. So always best to do what you can up front in terms of best practices and prevention, rather than having to deal with a lawsuit later on. Also, if you have been following those best practices and regulations, it's much more likely that that the suit will be unsuccessful or never even brought in the first place. So as far as COVID and construction goes, to date, there's been very little legal activity or workers' comp activity with respect to COVID. And, hopefully that will continue to be the case, especially as hopefully things continue to wane. So what about non-COVID construction exposures? Obviously, outside of sickness, we're left with injury. Most of you are aware by now, because we talk and write about it all the time, about New York scaffold law, labor law 240. Simply put, this law provides that there is strict liability, meaning basically liability without defense, for owners, developers, and general contractors with respect to height-related injuries to their workers, to subcontractor workers or contractors, workers' injuries on the job. So obviously, especially in New York, a very, very dangerous law for anybody in the construction and development business. Property owners may also be responsible for injuries from the general contractor or subcontractor's work. So the property owner is at risk as well as the GC. The GC is at risk for claims and injuries arising out of its subcontractor's work. So let's assume you've been sued. The question is going to be asked, will your subcontractor's insurance be responsible and respond? And, if we've said over and over and over again, if you have a certificate of insurance from your subcontractor, from your general contractor, if you're a property owner or developer, even if that certificate names you in black and white with bright lights as an additional insured, that alone is absolutely not enough. There are basically 3 requirements in order to transfer risk to your subcontractor and away from you as the building owner, developer, or even general contractor, and your insurance policy to keep your insurance clean. The first, as we've mentioned, is the certificate of insurance. It should have some key information and terms on it. First of all, it should show various policies are in force: the general liability policy, workers' compensation policy, commercial automobile policy, preferably an umbrella policy, and then as well, if applicable, a pollution liability policy and a professional liability policy if that contractor has exposures or is performing operations that may necessitate those types of insurance. There should be sufficient limits of liability insurance relative to the work being done. So if you have somebody laying brickwork or doing masonry work on the ground floor, obviously not a lot of exposure there. If you have somebody on a ladder up on a roof, up on scaffolding, or utilizing a crane, much higher liability exposure and worthy of higher liability limits. In addition, there's some key language that you should look for on the certificate of insurance in your favor, that being that you are an additional insured on a primary and non-contributory basis, meaning that your insurance is going to come first ahead of your contractor's insurance is going to come first ahead of your insurance, so that your insurance doesn't have to pay out. Secondly, that there's waiver of subrogation in your favor, so that after the contractor's insurance pays out, that contractor's insurance carrier does not have a right to come back after you or your insurance company for a case of negligence or partial negligence on your behalf. And then next would be per project aggregate. What that basically means is that if your contractor has $1 million worth of insurance, if he's on 20 different projects and he has a claim for $1 million, if he doesn't have per project aggregate, his insurance has been exhausted and he has no more insurance. So per project aggregate applies that $1 million limit to each and every project that the contractor is working on that you are named additionally insured on. So it's critically important in order to make sure that the contractor's insurance is there for you on that project specifically. Lastly, but probably most importantly, the certificate should state that there are no exclusions for injuries to the contractor or subcontractor employees for the type or location of work performed. So a lot of times you'll have a contractor like a roofer. He's looking to save some money on insurance. He goes out and gets an interior carpenter policy that could be 1/100th of the cost of a roofing policy. But it's very possible that that policy has an exclusion for roofing. So if there is a claim, if someone gets injured and they come back after you and sue you and you say, well, I'm an additional insured on my contractor's policy, I should be fine. Contractor's insurance should respond. But if there's that exclusion there for roofing, you're in trouble and your insurance will have to respond, and that will not be good for your future insurance ramifications. Okay, secondly, after the certificate of insurance, you have to have a written agreement. The written agreement has to have an indemnification clause in your favor, and it has to have an insurance requirement where the contractor is required to maintain the insurance limits and types that I had noted previously on the certificate. So if you don't have the written agreement, the certificate alone is not enough. The certificate of a loan will not trigger coverage for you. It's the written agreement that is typically the trigger for coverage on the contractor's policy for an additional insured. And then lastly, even if you have the certificate of insurance and you have the written agreement with everything required of the contractor, you still should have your broker review the actual insurance policies, the liability insurance policies of the contractor. Because a lot of times a contractor is going to sign off that he has anything and everything that you've asked for. He'll have no problem signing an agreement, acknowledging that he's got that. He can even have a certificate that appears to have what you need, but all of those things can happen and his insurance policy still might not have what it's supposed to have. So a review by your broker to make sure that it's compliant is the smart thing to do. So what about various insurance policies? Are all of these insurance policies that are available today on the market, are they really necessary? First of all, there are some standard liability related policies that all contractors should maintain, and you're very familiar with these. General liability insurance, workers' compensation, employers' liability, and New York State disability insurance, all required for companies that have multiple employees. Commercial automobile policy, including hired and non-owned automobile. A lot of times contractors, especially smaller ones, will use their own personal vehicles that are insured by them personally. That's unacceptable. If that's the setup that your contractor has, at the very least, they have to have something called hired and non-owned auto insurance so that their personal vehicle, if it's involved in an accident and there's liability related to it, the commercial policy will pay not just the low limits of the personal liability, automobile liability policy that he might have as an individual driver. And then the umbrella and excess liability policy covers over the top of the general liability, the employer liability, and the auto liability. Umbrella liability could start at $1 million, could go up to 5, 10, or even higher, depending on the size of the contractor and the type of work being done. But what about finally the other liability related policies that should be considered besides the ones that I just mentioned, which are virtually mandatory? If you're a developer or a project owner, you might want to consider getting a job-specific owner's interest liability policy as a backup policy, just in case the general contractor's policy where you're named insured fails. How could this happen? One example would be there's an injury on the job, subcontractors, workers injured, the GC gets sued, the project owner, the building owner gets sued. You look to the general contractor's insurance policy to respond as an additional insured, but lo and behold, general contractor didn't pay their insurance premium the day before and their policy canceled. So unbeknownst to you, there's no coverage. If you don't have a job-specific owner's interest liability policy, you could be faced with paying those legal bills to defend yourself out of pocket. So it's basically like a belt and suspenders policy. Next, there's employment practices liability. These policies respond to things like employees claiming that they were discriminated against. There's oftentimes a limited amount of coverage for wage and hour claims, or if third parties like bystanders or office employees on a job who claim that your employer or your contractor's employee harassed them or assaulted them. So discrimination, age, sexual orientation, religion, those types of things, race, those types of claims are responded to by an employment practice liability policy, excluded by a general liability policy. Professional liability should be considered if your contractor is involved in design build work or value engineering work. Many contractors will say, I don't do any of that stuff. I'm not the contractor. I'm not the one that stamps the plans. You don't have to stamp a plan to be held liable if you made a back of the napkin, change in how you're going to build something or construct something in order to save some money or expedite the building process. So professional liability can come into play even if you're not a licensed professional that stamps off plans. Pollution liability should be considered for all operations involving pollutants, such as lead paint removal, any types of chemicals, or if there's digging. When you dig, you don't know what's underground. There could be an underground tank there that's 50 years old, that's got oil still in it that wasn't properly decommissioned. And if your contractor pierces that tank and oil goes all over the place, that could be your liability if it happens on your land. A pollution liability policy from the contractor or the project owner may be critical. And finally, we talked about this in an earlier presentation, cyber liability, the effects of cyber assaults, cyber attacks on businesses, large and small, are happening more and more and more every day. Ransomware, malware, fraudulent money transfer schemes, etc., theft of personally identifiable employee information. All of that is liability for a contractor that you would have never thought would have been an actual contractor exposure, but in this day and age, it is. So with that, I will turn it back over to Tim that addresses the insurance side of pitfalls for contractors.
Wonderful. Thank you so much, Jason, and thank you to all our panelists for such a wealth of information. We do have a number of questions that we would like to try to get to within our few remaining minutes. The first one, are the plans for residential housing employees, is there a sample plan that would cover the HERO Act for those types of employees on the Department of Labor website?
Yes, there are. Just go to the DOL website. They have an entire page devoted to this. They're available in multiple languages, which is actually another requirement of the statute. You have to provide it in the primary language of your employees if it's other than English.
Great. Next question. Should you have all the insurance requirements even if the project is covered under WRAP? If not, what is the minimum set of requirements?
So that's a great question. Normally, a project owner or a general contractor who's covered under either an owner's policy, WRAP policy, or a contractor's WRAP policy, an OSIP or a CSIP, will still require and have minimum requirements for all of the subcontractors on that job. And that is because there are certain types of claims that may not be covered by the WRAP policy. If the bodily injury claim is work-related, but happens to happen like a certain number of feet, 1,000 feet or what have you, away from the job site, and it's not deemed to be covered by the WRAP policy, then the contractor's insurance would be critical. If the WRAP policy only goes for 3 years after the job is completed, and there's a completed operations claim that happens in the 4th or 5th year before the statute of limitations runs out, that would necessitate a contractor's own insurance policy. So yes, even if the project's covered by a WRAP, the contractors still need to have their own insurance.
Great. Next question. Is it worth it for me to break up my project into smaller projects and create multiple entities so that I can avoid liability under the Wage Theft Act?
Right. So the answer to that question is no. That level of complication doesn't protect you at all. Courts will not recognize such attempts to avoid the statute, number one. And number two, there is an exception for wage claims. So even if you try to shield yourself from that type of liability in closely held corporations, the shareholders are directly liable for non-payment of wages.
Next question. The Joint Labor Management Committees under the HERO Act, do I have to create those?
No, actually, for the employer side of it, there is nothing to be done other than not to interfere with their creation. That is something for the employees to create if they so wish. You need to cooperate with it, but there's nothing for you to actually do.
Great. Next question. If I have an umbrella policy for insurance, doesn't that cover me for everything not covered by the other policies I have?
Yeah, Tim, that term umbrella policy is really a misnomer. An umbrella policy in simple terms really only covers for an additional amount of insurance over and above what underlying policies like the general liability policy or the auto liability policy have already covered. So if you have a $1 or $2 million general liability policy and you go through that limit, that per occurrence limit, and the claim ends up being $3 million, then hopefully you have a $1 million umbrella or more to pick up the uninsured portion of the claim from the general liability. An umbrella policy does not have things built into it like employment practices and professional liability and pollution liability, all under one umbrella. You have to buy specific individual policies for those exposures. They're not covered by the umbrella.
Okay. And then the last question we have here in the queue, I've heard that there are some amendments possibly coming to the Wage Theft Act. Do you know anything about that?
Yes, the only one that seems to be making it through is the addition of a 10-day notice provision to be provided to the contractor in advance of any litigation for failure to pay wages.
Wonderful. So with that, again, I want to thank very much our panelists today. I want to thank the Business Council of Westchester and our co-sponsors for this event with Levitt First Insurance. If this series did not address a topic that's of a particular use to you, the Building and Realty Institute produces a lot of content that's trying to keep our members up to date, and we'd be happy to look at the possibility of doing a future program on us. You can always find us at www.buildersinstitute.org. So with that, I want to turn it back over to John.
Tim, thank you very much, and thank you to this great panel. They covered a lot of good ground. As you all know, the Business Council of Westchester is the largest business membership organization focusing on advocacy. And some of the legislation that was covered today, the HEROES Act, the Wage Theft Act, we vehemently opposed and continue to raise major concerns of, and will continue to raise major concerns as these laws are implemented. And as we go into the 2022 legislative session, we'll continue to keep our eyes laser focused on legislation that hopefully some is positive for your industries, But those that are negative, we will raise the red flags as quickly as possible. I again want to thank the Building and Realty Institute, BRI, and Levered First Insurance. I urge anyone who watches this show to reach out to these two great organizations if you can use their assistance and help. They are true leaders in Westchester County. And thank all of you for tuning in. Again, this broadcast will stay on our business resource page so that if you missed part of it or you want to refer people to it, it will be there for them to go to watch. Thank you all again. Stay safe.
Thank you.
Thank you.
Thank you.